Kibaki, President and Commander-in-Chief of the Armed Forces of the Republic of Kenya, declare that the Constitution set out in a schedule shall be the new Constitution of Kenya with effect from the 27th August, the year 2010.
The celebrations of the 2010 Constitution promulgation remain vividly fresh in our memories. But the most important question today we ask ourselves, for these 16 years, what has been the effectiveness of this precious document? Despite the myriad of challenges, the Constitution, the threats it continues to face, we must have a beaming smile that the constitutional order has been effectively implemented to a certain good percentage for these 16 years. Today in your workplaces, today in your social halls, in the sanctums of prayers that you are in, let us honor the Constitution 2010. It is the most precious document we have in this country to ensure that everyone is equal before the law. Good morning, viewers, Kenyans. Welcome to Court Helicopter Trending News. Today, we mark 16 years since the promulgation of the Kenyan 2010 Constitution, which was founded at the very historic Uhuru Park. The celebrations of the 2010 Constitution promulgation remain vividly fresh in our memories. But the most important question today we ask ourselves, for these 16 years, what has been the effectiveness of this precious document? Without going deeper into the history of constitutional making, we must recognize the heroes and the heroines of this country who fought so hard through blood and sweat to ensure that concessions were made, conversations were had in boardrooms for us to come up with this document. So without accounting for history, we will be losing the conversation on this area. Allow me to address that old woman in Kwale County. Allow me to speak to Wafula in Bungoma County. Allow me to speak to Guyo in Isiolo County. Allow me to speak to that old woman every day who wakes up with going to the fish market in my good village, Takaungu. Allow me to speak to the Kenyans in diaspora that today is a day we must honor sincerely as we move forward in this great republic. In 1986, 3 judges sat in a very famous case, the Stanley Munga Githunguri versus Republic. The bench was led by the then Chief Justice, C.B. Madan. In one of the profound statements made in the judgment, the court interrogated itself to ask one question. What is the importance of the Constitution if it does not mean to protect the fundamental rights of the people who have adhered to it? Remember, it is the people who donate these powers and delegate it to public authorities for us to have order within the constitutional dispensation. Today, viewers, I would like to speak to a question so dear in our daily bread search. This is the right to fair trial and the right to bail and bond. One of the most profound rights entailed in the 2010 Constitution is the right to bail and bond. Previously, in 2008, the celebrated case of Republic versus Danson Mugunya and another at the historic corridors of justice in Mombasa. Justice Mohammed Ibrahim, the late Justice Mohammed Ibrahim, the judge of the Supreme Court of Kenya, made a very profound ruling on welcoming and ushering in the Constitution 2010. The first major issue of decision at that very court was these two accused persons had been remanded from the 13th day of October 2008 to 13th day of October 2010. Previously, remember, the previous constitutional dispensation did not allow bail and bond on capital offenses such as murder. With that case in mind, Justice Mohammed Ibrahim, the late, made these profound statements that in the current dispensation of the 2010 Constitution, no offense is non-bailable. So everyone has the access to bail and bond, considering a lot of considerations at the trial. This is not an absolute right, remember. This right can be limited given a number of reasons. So this 2010 judgment that was delivered in Mombasa redefined our history in terms of the right to bail and bond. Remember, if you are an accused person, the central principle outlined in our Kenyan Constitution is the presumption of innocence until proven guilty. So with this milestone that the Constitution has made to us Kenyans, we must celebrate and honor its effectiveness within the midst of the Republic. Another issue with regard to the right of the accused in a trial, the right to remain silent. This is a very cogent right entailed in our Kenyan 2010 Constitution. So Kenyans from all walks of life in this republic, this right has always been effectively implemented throughout these 16 years since the promulgation of the 2010 Constitution. With that in mind, allow me to also address a number of issues within the Constitution. So this basic Bill of Rights, which entails a number of more rights, the right to a healthy environment, the right to access education, these rights are inherent, given unto us by the nature of us becoming human beings. These rights are not given to us as a favor. These are fundamental rights and freedom we must enjoy at all material times. Despite this right to bail and bond being within the midst of our courts, it has faced numerous challenges. So these challenges that it's facing, we remind that this right has a historical imprint, so that it can forever be safeguarded within the 2010 Constitution. I will go to the very heart of one of the profound statements made by the Supreme Court of Kenya in 2017 when they were issuing the judgment, the election petition filed by the late Honorable Raila Amolo Odinga. The Supreme Court made a very fundamental statement that let the majesty of this Constitution spread across our motherland. Let the vibrancy of this Constitution sprout from the trees. Let it occupy our living rooms. So this statement was very fundamental to ensure that the Constitution, however it is, it must be respected and it must be honored within the realm of the 2010 Constitution. So wherever you are as a Kenyan today, I want to remind you of this great day. This day must be honored, must be celebrated. And we thank many, many stakeholders from the Kenyan, the normal Kenyan, from the civil society organizations, from the advocates who every day they go to court to defend this Constitution. All of us must play the bigger role to ensure the Constitution 2010 continues to thrive and to freely be honored in our motherland. As we finalize this conversation on constitutionalism for the last 16 years. One of the most underpinning problem and challenge we are facing is the dishonor of court summons. Summons by court are key in effecting the ambits of the rule of law. When the court of law summons someone to appear before it, it is the people who have delegated this authority to the court. It is what some courts call contumacious disobedience. We must reflect that no one is above the constitutional order. We are all, as a people, public officers, businessmen and women. Whenever the court summons you, you must respect, oblige, and submit to the one fundamental order, the Constitution of Kenya 2010. In conclusion, despite the myriad of challenges, the Constitution, the threats it continues to face, we must have a beaming smile that the constitutional order has been effectively implemented to a certain good percentage for these 16 years. Today in your workplaces, today in your social halls, in the sanctums of prayers that you are in, let us honor the Constitution 2010. It is the most precious document we have in this country to ensure that everyone is equal before the law. Thank you.